Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope you're having a wonderful day. For today's episode, we are going to do a deep dive into a historical Supreme Court case that came out when I was still in law school, as part of our celebration of welcoming the U.S. Supreme Court back into session. For those of you who may not be familiar, the U.S. Supreme Court meets from the first Monday of October until the last day of June, so it takes the summer off. So the Supreme Court is back in session, and we have already covered one of those oral arguments that's been held this term, dealing with the Americans with Disability Act and people who are called testers, people who don't really necessarily have a claim under their own right, but would like to test the law in order to make sure that there's compliance. While we'll try to deal with that issue, let's go back in time and deal with an older case that deals with property law and what it means to own property and when the government can take that property from you for what would be public use. So this was the issue in New London, Connecticut. The city of New London wanted to develop an area for a pharmaceutical company that they thought would bring in a lot of revenue and jobs and bring in trade into New London. They thought it would be good for the city. Where the pharmaceutical company wanted to build, however, there were already developments in place, including, critically, one pink house. And they wanted to buy this land for the purpose of developing it into this pharmaceutical plant, and the woman of the pink house didn't want to sell. So they proposed to seize the house by use of eminent domain under the Fifth Amendment. There shall be no taking of private property except for public use with just compensation. So they were willing to pay her a fair market price, which we'll get into what that is or is not, as a separate side issue. But more of the key question here was, is this a public use to give it over to another private entity? Or is this a different thing? So if we were trying to build a school or build a fire department or build a highway or a police station or a jail, then I think everyone would say, yeah, that's a public use. That is for the public's good. And the fact that your house happens to be there, well, that's unfortunate and all, but the road got to go there, yo. But this is not that, right? This is not a public facility in the normal sense, but maybe it's public enough because the number of jobs it will bring into the area, the revenue it will bring in, and so forth and so on. Maybe that makes it public enough. So that's what the Supreme Court is dealing with in this issue. Is this a public use? Can we seize the properties, including the little pink house, for the purposes of handing it over not to a school or to a firehouse or a police station or a jail, which would be owned by the government, but rather handing it over to another private entity, namely this pharmaceutical company who wants to develop the area. All right, so with all that in play, we're going to read the decision in full so that we can best understand the Supreme Court's reasoning. I remember when this came out when I was in law school, and I thought it was pretty stupid. But of course, that was 20 years ago, and maybe I've had different thoughts since then. So it'll be interesting to see if my opinion at all has changed as I've read more and more cases and become more and more well-informed. So let's take a look at this opinion and see what the Supreme Court had to say. Justice Stevens delivers the opinion of the court in Kelo versus New London by writing the following. In 2000, the city of New London, Connecticut, approved a development plan that, in the words of the Supreme Court of Connecticut, was projected to create in excess of 1,000 jobs, to increase tax and other revenue, and to revitalize an economically distressed city, including the downtown and waterfront areas. In assembling the land needed for the project, the city's development agent had purchased property from willing sellers and proposes to use the power of eminent domain to acquire the remaining of the property from unwilling owners in exchange for just compensation. The question presented is whether the city's proposed disposition of the property qualifies as a public use within the meanings of the taking clause of the Fifth Amendment to the Constitution. And in a footnote, it contains the relevant clause of the Constitution, which simply says in relevant part, nor shall private property be taken for public use without just compensation, which of course implies the opposite. You can take it for public use with just compensation. So it wasn't that we're not willing to pay you, it's whether or not this is public use. That's the principal issue here. The city of New London sits at the junction of the Thames River and Long Island Sound in the southeastern corner of Connecticut, Decades of economic decline have led a state agency in 1990 to designate the city a distressed municipality, which I imagine has some sort of consequences as a matter of state law. In 1996, the federal government closed the Naval Undersea Warfare Center, which had been located in the Fort Tuberville area of the city and had employed over 1,500 people. In 1998, the city's unemployment rate was nearly double that of the overall state, and its population of just under 24,000 residents was at its lowest since 1920. So things have not been going particularly well for the city in at least relevant history. These conditions prompted state and local officials to target New London and particularly the Fort Tuberville area for economic revitalization. To this end, respondent New London Development Corporation, a private nonprofit entity established some years earlier to assist the city in planning economic development, was reactivated. In January 1998, the state authorized a $5.35 million bond issue to support the NLRDC's planning activities and a $10 million bond issued towards the creation of Fort Tuberville State Park. In February, the pharmaceutical company Pfizer announced it would build a $300 million research facility on the site immediately adjacent to Fort Tuberville. Local planners hoped that Pfizer would draw new business to the area, thereby serving as a catalyst for the area's rejuvenation. After receiving initial approval from the City Council, the NLDC continued its planning activities and held a series of neighborhood meetings to educate the public about the process. In May, the Council authorized the NLDC to formally submit plans to relevant state agencies for review. Upon obtaining state-level permission, the NLDC finalized an area for integrated development focused on 90 acres of Fort Tuberville area. So we got the basic gist of this thing down, right? The city of New London has been designated both by its own city and by state-level authority as a distressed city. Things have been better in the city. It used to hold, some naval aspects for the Navy, but the Navy stopped using the area for that. So that cost 1,500 jobs, and things have not been going particularly well in the area. The population is way down, the revenue is way down, and we're in a vicious cycle, as often happens, right? Less revenue means less development, means less people want to come to the area because there's less things there, means less revenue, means less taxation, right? We're in a bit of a death spiral. Things are going downwards. The very fact people don't want to live there means less tax revenue, less money to do things, so we can't make things nice. So less people want to live there, which means even less tax revenue, and we're on a downward trend. So to try to reverse all this, we have a plan in place. We've put someone together to say, hey, can you help us fix the area? So that is sort of what's going on here in the grand scheme of the thing. And one of the things that we'd like to do as part of this is Pfizer is interested in building a research complex worth $300 million in the area, which obviously brings in a tax base and also jobs and prosperity, or at least that's the idea. So that's what they're looking at in the area. Okay, so we've gotten the approval from all the relevant state level authorities to sort of go down this road, so we'd like to pursue that. The Fort Tuberville area is situated on a peninsula that juts into the Thames River. The area comprises approximately of 115 privately owned properties as well as 32 acres of land formerly occupied by the naval facility. The state park now occupies 18 of those 32 areas. The development plan encompasses 7 different parcels. Parcel 1 is designated for a waterfront conference hotel at the center of a small urban village, which will have restaurants and shopping. This parcel will have marinas for both recreational and commercial use. A pedestrian river walk will originate here and continue down the coast, connecting the waterfront area of the development. Parcel 2 will be the site of approximately 80 new residences organized in an urban neighborhood and linked by public waterway into an urban neighborhood and linked by public waterway to the remainder of development, including the state park. This parcel also includes space reserved for a new U.S. Coast Guard museum. Parcel 3, which is located immediately north of the Pfizer facility, will contain at least 90,000 square feet of research and development space. Parcel 4A is 2.4 acre site that will be either used to support the adjacent state park, to provide parking or retail services for visitors, or to support the nearby marina. Parcel 4B will be included in a renovated marina as well as a final stretch of the Riverwalk. Parcels 5, 6, and 7 will provide land for office and retail space, parking, and water development commercial uses. So what we see here is that we've put together a pretty thorough plan. We have taken a look at this area. We'd like to redevelop it. We have 7 sort of zones, if you like, and here's how we want to redesignate those 7 zones. And here's our broad vision for how that will help the area by various means to revitalize this area of Connecticut. Okay, the NLDC, for its part, intended the development plan to capitalize on the arrival of the Pfizer facility and the commerce it was expected to attract. In addition to creating jobs, generating tax revenue, and helping to build momentum for a revitalization of the downtown New London area, the plan was also designed to make the city more attractive and create leisure and recreational opportunities on the waterfront and in the park. The City Council approved the plan in January of 2000 and designated NLDC as its development agent in charge of implementation. So NLDC is a private entity. They were tasked by the city to go forth and put together a plan. The NLDC put together a plan and the city's like, yep, that looks good for us. We like that plan. So we are designating you to be the government. No problem there. That's perfectly fine. We have basically commissioned them. Fine. Deputize them if you like. That's fine. The City Council authorized NLDC to purchase property or acquire property by exercising eminent domain in the city's name. This is perfectly fine, right? NLDC is a private entity, but we're giving them state level power. We've deputized them. We've given them a sheriff's badge. They're now the state. Fine, no problem. You can do that. That part's fine. The NLDC successfully negotiated purchase of most of the real estate in the 90-acre area, but its negotiation with the petitioners that are brought here failed. As a consequence, in November of 2000, the NLDC issued condemnation proceedings that gave rise to this case. So the city, acting through its agent, a private entity, but through its agent, so now it's the public entity, all as surely as it were the government itself, is now wanting to develop these 90 acres. So they say, go forth and buy it. So they do. But Kelo doesn't want to sell. Kelo and her little pink house don't want to sell. She does not want to sell. She'd like to continue living there. Okay. So they say, all right, we're going to force you to sell. We're going to condemn the property and take it through eminent domain for public use. NLDC is acting in the name of the city. So, okay, they want to try that. Let's learn a little bit more about the petitioner. Petitioner Suzette Kelo has lived in Fort Trumbull area since 1997. She's made extensive improvements to her house, which she prizes for the water view. Petitioner Wilhelm Derry was born in Fort Trumbull House in 1918 and lived there her entire life. Her husband Charles, also a petitioner, had lived in the house since they married some 60 years ago. In all, 9 petitioners that are before this case own a total of 15 properties in Fort Trumbull, 4 in Parcel 3 of the development plan, and 11 in Parcel 4A. So it's not just Miss Kelo, it's some other people, but of course, the case gets named after Miss Kelo. So other people are similarly situated. They all own property. They own at least these petitioners own 15 properties in the areas. 10 of the properties are occupied by owner or family member. The other 5 are held as investment properties. There's no allegation that any of the properties is blighted or otherwise in poor condition, rather condemned only because they happen to be located in the development area. So that's another reason that these properties might, at least in theory, be condemned because they are blighted, which is a technical term, right? The properties are unsafe. They are decrepit. They are derelict. They are an eyesore, a safety sore, and everything else, right? The properties have fallen in such disrepair that they have become completely unmanageable. So this is the normal sense of condemnation. If you ever heard of property being condemned, this is normally what it means. And condemnation, of course, can come in different varieties and flavors, depending on exactly what we're talking about. But that is one of the reasons the government might seize your property. Your house, your business, your factory, your whatever has become so unsafe, so decrepit, so uncared for, so whatever, that we're going to literally raze it to the ground because it is no longer safe and fit for use. But that isn't the situation here. That isn't the situation here. We're not condemning these properties because they're no longer fit for use. They're fit for use. We're condemning them because they're in the way of our plan. And so we're condemning them through eminent domain. So that's a way to condemn, but they make the distinction here. Fine. In December of 2000, the petitioners brought this action in the New London Superior Court. They went to trial court. They claimed, among other things, that taking their property would violate the public use restriction in the Fifth Amendment. After a 7-day bench trial, the Superior Court, the trial court, granted a permanent restraining order prohibiting the taking of the properties located in Parcel 4A. It, however, denied relief as to properties located in Parcel 3. So they take a look at the facts as they are related, and they grant some relief to some people and some relief not to other people. Okay. After the Supreme Court ruled, both sides took appeal to the Supreme Court of Connecticut. That court held over dissent that all the city's proposed takings were valid. So they've gone from trial court to the Supreme Court of the state. Fine. The Supreme Court of the state therefore holds all the takings are valid. It began by upholding the lower court determination. The takings were authorized by the state municipal development statute. There's some statute in question which says the state can do this, which, fair enough. If the state doesn't have power in the first place, then this is pointless, but the state has power. So the question is not the statutory issue, the question is the constitutional issue, but you begin by noting that they have power under the statute. That statute expresses a legislative determination that taking of land, even developed land, as part of economic development projects is public use and in the public interest. So the legislature of Connecticut at least seems to think that this qualifies as public use as far as they're concerned. Next, relying on cases such as Hawaii Housing Authority and Burman, this court held that economic development qualified as valid public use under both federal and state constitutions. And Hawaii Housing Authority is a pretty interesting case that even speaks to a potentially broader proposition. Hawaii Housing Authority is a really interesting case. The government of Hawaii in 1980s thought that too much land was held by too few people in Hawaii. Hawaii, of course, is a state that's somewhat smaller than some other states, and of course is broken up by it being among island chains. So it's a fixed amount of land, and also very desirable by its nature because of its tropical donation. A lot of people like Hawaii. But the state of Hawaii, its government thought that too much land was held by too few people. So the state of Hawaii basically solved this problem by eminent domaining everyone's property who owned more than a certain number. And the number we've covered before in prior cases, or prior discussions rather, but it was a small number. It wasn't very much in the grand scheme of things. So they condemned anyone that had arguably more than just personal use for a personal home. They basically condemned everyone's ownership and said, we're going to seize it all and redistribute it so it will be more equitable. And the Supreme Court upheld that. So Hawaii Housing Authority goes a long way, right? How about we just seize everyone's land and we resell it to people in a more equal way? So that was Hawaii Housing Authority. So that's a pretty notable case. So the court, of course, held that those economic developments qualify as public use, which, fair enough. They sure did. Finally, adhering to precedent, the court went out of its way to determine whether takings of a particular property issue were reasonably necessary to achieving the city's intended use, and second, whether takings were for reasonably foreseeable needs. The court upheld the trial court's factual finding as to Part 3, but reversed the trial court's finding as to Part 4A, agreeing with the city that the intended use of the land was sufficient to define it as being given reasonable attention during the planning process. So the thing that makes it viable for the government to do this is their plan. So that's what makes it necessary. What makes it necessary is the government has put together a plan. Could the government have put together a different plan? Sure, I suppose they could have, but they chose this plan. So the plan is the execution of taking of this property is necessary towards the execution of the plan, which also is sort of parallel by the US government as it relates to the necessary and proper clause when it comes to US Congress, right? They have the power to make necessary and proper laws. So as they have power to do things, those things become necessary and proper because they've deemed them to be so. So that makes sense by parallel construction. The three dissenting justices would have imposed a heightened standard of judicial review for takings justified by economic development. Although they agreed the plan was intended to serve a valid public use, they would have found all takings unconstitutional because the city failed to adduce clear and convincing evidence that the economic benefits would in fact come to place. So three dissenting justices said, we need a higher level of review. We need more confidence. So they're not necessarily disagreeing with the idea, they're just disagreeing about how certain do you have to be. All right. We grant certiorari to determine whether the city's decision to take property for the purpose of economic development satisfies the public requirement of the Fifth Amendment, which of course is sort of the ultimate thing here for the federal government. So the state of Connecticut has passed law saying that this is authorized, but of course the state can only authorize as far as the Constitution will allow it. And if there's a Fifth Amendment interest here, then the state's law obviously has to bend. So we do have some ideas from precedent that economic development is a valid reason to seize property within the meaning of public use, but this is a somewhat novel construction, at least as it relates to this. So the Supreme Court has to sort of tease out this issue. All right. Two polar propositions are perfectly clear. On the one hand, it's long been accepted the sovereign may not take property of A for the sole purpose of transferring it to another property B, even if they're paid just compensation. So we have this in the case law, right? We can't take it from A merely to give it to B. That isn't a public use because B in this scenario is a private person, right? A is a private person, B is a private person. So the government can't force the sale from A to B, one private person to another, because that is not within the meaning of public use. So we know that. On the other hand, it's equally clear that a state may transfer property from one private party to another if future use by the public is the purpose of the taking. So the idea again being that it benefits the public in a public way. So that's the distinction we're trying to draw, right? Merely taking property from one person and giving it to a private person in a private way versus taking property from a private person and giving it to a private purpose in a way that is for the public's enjoyment. The condemnation of land for railroad with carrier duties is a familiar example. So a railroad is and typically can be privately owned. So that makes sense, right? The railroad might be owned by a private person, might be owned by a private entity. But the mere fact that the railroad has to travel through there, it's for the public at large. So we've transferred property from A to B, one private party to another, but in the case of the railroad, for the ability of commerce to commence, which benefits everyone, at least generally, as it benefits the person who has the railroad. And obviously your ability to move the railroad can only go so far. It's got to go somewhere. And sometimes, depending on details, your options are more limited than you might expect. So in the name of, connecting the states with roads and interstates and railroads, your property might have to go. The Supreme Court then notes that neither of these propositions determines disposition of this particular case because this case isn't quite like either of those, right? This isn't quite like giving it from one private landowner to another private landowner, nor is it giving it from one private landowner to a landowner who, by the nature of what they do, is serving the public in a general way like a railroad. This is something a little bit different. As for the first proposition, the City of New London would no doubt be forbidden from taking petitioners' land for the purpose of conferring a private benefit on a particular private party. A purely private taking could not withstand scrutiny of public use requirement. It would serve no legitimate purpose of government and thus would be void. Nor would the city be allowed to take property under mere pretext of a public purpose when its actual purpose was to bestow a private benefit. So as always, we don't necessarily care what you say on the label. We will look past the label in order to determine if what you're doing is really what you say you're doing. So you merely saying, oh, this is for the public in a public way, we will look past that and figure out what's really going on. The taking before us, however, would be executed pursuant to a carefully considered development plan. The trial judge and all members of the Supreme Court of Connecticut agree there is no evidence of illegitimate purpose in this case. So this doesn't appear to be one of those situations. It doesn't appear to be a mere pretext. This really is part of a development operation. This really is just being done in a very sort of global way. They weren't trying to target the little pink house in particular. They weren't trying to transfer the little pink house to anyone in particular with respect to the little pink house. The little pink house just happened to sort of be there and in the way. So this is not sort of that pretextual case, and I would tend to agree that is not brought out by these facts. Therefore, as was true of a statute challenged in Midkiff, the city's development plan was not adopted to benefit a particular class of identifiable individuals. It wasn't developed for that purpose. It wasn't developed for the purpose of trying to benefit somebody. It may have that result, it may have that end, but that wasn't the goal in and of itself. The goal was economic development. And the fact that it just so happened to benefit private parties is a consequence, not a target of the legislation, and that makes a big difference there. On the other hand, this is a case. On the other hand, this is not a case. On the other hand, this is not a case in which the city is planning to open the condemned land, at least not in its entirety, to be used by the general public. The entire thing is not being turned into a park, for example. Nor will the private lessees of the land in a sense be required to operate like common carriers, making their services available to all commercial comers. So a railroad is a common carrier, of course, as a technical sense, which means that makes them open to the public, at least in the first instance. You have to sort of serve everybody unless they violate your terms of service or their contracts. So an airline is a common carrier, a railroad is a common carrier. They have to serve everyone unless, some specific person violates their rules. But although such projected use would be sufficient to satisfy the public use requirement, this court long ago rejected any literal interpretation that condemned property be put into use for the general public. So public use doesn't require them to be a public asset like a park or a street. We're willing to look a little bit past that. Indeed, while many state courts in the mid-19th century endorsed use by the public as a proper definition of public use, that narrower view has steadily eroded over time. Nor was use by the public test difficult to administer. What portion of the public needs to have access to the property and at what price? But it has proved impractical given the diverse and always evolving needs of society. So one of the things that we tried to do, at least in the past, was looking at this by how much the public was able to use it. But those tests proved to be a bit unworkable. As we tried to apply them, we couldn't actually make them work in person, which often happens in law. You try something and then it doesn't quite work. The reality of trying to implement something, it doesn't quite work. And then when it doesn't quite work, you have to reevaluate. So that was the situation here. When we tried to do the use by the public test, we found it difficult to administer what that exactly meant. So we sort of gave up because they were unworkable. Accordingly, when the state begins to apply the Fifth Amendment to the states at the close of the 19th century, it embraced the broader and more natural interpretation of public use as public purpose. Thus, in the cases upholding a mining company's use of an aerial bucket line to transport ore over property it did not use, Justice Holmes' opinion for the court stressed the inadequacy of use by the general public as a universal test. So when we put the buckets to take mining stuff, over the roads and over people's properties, that was the public use test didn't really quite work. So it had to be evolved. We've repeatedly and consistently rejected the narrow test ever since then. The disposition of this case therefore turns on the question of whether the city's development plan serves the public purpose. Without exception, our cases have defined that concept broadly, reflecting our long-standing policy of deference to legislative judgments in the field. So we tend to look at this in a very sort of broad way with charity towards the state action is how we're going to do this. The state determines that it's a public purpose, and we're going to give them a lot of deference in making that determination. There is a policy determination here at its core about what makes something a public purpose. And the very fact that the legislature votes on it in some sense makes it a public purpose because the government is representing the public and representing what the public interests are. So there is something that is sort of, at least superficially, very available about that. We might challenge it, we might look past that, but the idea that we're going to give deference to the legislature, who are of course accountable to their constituents, in the first instance, for them determining what's a public purpose because it needs a law, there's a lot of sort of principles of the Republican democracy built into that. So we can look past that, but we're going to give some deference to it initially. In Burman versus Parker, this court upheld a redevelopment plan targeting a blighted area of Washington, D.C., in which most of the housing for the area's 5,000 inhabitants was beyond repair. Under the plan, the area would be condemned, and part of it utilized for construction of streets, schools, and other public facilities. The remainder of the land would be sold or leased to private parties for purpose of redevelopment, including construction of low-cost housing. The owner of a department store located in the area challenged the condemnation, pointing out that his store was not itself blighted, and arguing the creation of a better balanced, more attractive community was not a valid public use. So the government of DC thinks, okay, this bit of DC is blighted, right? This bit of DC has some problems. So we'd like to declare the entire area to be blighted in a sort of global way that affects everybody. And this guy was like, well, my store is inside this zone, and my store's not blighted. My store is working great. So you have not dealt with this with enough nuance, the guy who owns the store says. The Supreme Court disagrees. Writing for a unanimous Supreme Court, Justice Douglas refused to evaluate the claim in isolation, deferring instead to the legislative and agency judgment that the area must be planned as a whole for the plan to be successful, which of course makes some sense. The government has to look at things in a sort of a global way with a 30,000-foot overview. It can't necessarily look at every single house individually, and even if it couldn't develop plans in such a way. It needs to be able to take wide swaths of land and say, well, this is true about the land in general, and if it is true about the land in general, then we'll deal with it in a general way, and the specifics are sort of inconsequential, which makes sense. You've got to look at it at the right level of resolution. And here we think the right level of resolution refers to the area of the whole, and the findings of the government with respect to this area of DC make sense on the whole. The court explained that for community redevelopment programs need not, by force of the Constitution, be on a piecemeal basis, lot by lot, building by building. The public use underlying the taking was unequivocally affirmed. The Supreme Court writing, we do not sit to determine whether a particular housing project is or is not desirable. The concept of public welfare is broad and inclusive. The values it represents are spiritual as well as physical, aesthetic as well as monetary. It is within the power of the legislature to determine that a community should be beautiful as well as healthy, spacious as well as clean, well balanced as well as carefully patrolled. In the present case, the Congress and its authorized agencies have made determinations that take into account a wide variety of values. Incidentally, they're talking about Congress because at this period of time, the Home Rule Act hasn't been passed yet, And so Congress is still legislating DC on a very individual basis. That wouldn't happen until the 70s with the Home Rule Act, but even where the Home Rule Act did apply, the Congress, of course, could still overrule it because it's within the territory of the United States government as a whole. But that's neither here nor there. So Congress has made this determination. It's not for us to reappraise them. If those who govern District of Columbia decide the nation's capital should be beautiful as well as sanitary, there's nothing in the Fifth Amendment standing in their way. Which again, kind of makes sense, right? You think about these things, and you think about Hawaii Housing Authority, you think about this case dealing with DC, you think about other things the government is doing, and you kind of have to do things in a very global way. If you wanted to build a military base, the military base is going to need so much land. It's going to go here. That's going to impact individual people who might not like that, but you got to do things in a very sort of systematic way, in a sort of global way, because the government tends to think big. Its programs tend to think big. That's sort of how it rolls. Okay. In Hawaii Housing Authority versus Midkiff, this court was tasked to consider a Hawaii statute whereby fee title, which is the normal kind of title that people own. Fee title is just you own the place. It's yours. It's in your name. Was taken from lessors, the people who were leasing the land, and transferred to lessees, the people who are renting the land. So if this is fee title, someone owns the land, it's being rented, and how about the person who's the renter is now the landowner? That's Hawaii Housing Authority. The renter is now the owner. Okay. In order to reduce the concentration of land ownership, we unanimously upheld the statute and rejected the Ninth Circuit's view that it was a naked attempt on the part of the state of Hawaii to take property of A and transfer it to B solely for B's private use and benefit. So again, this is a very interesting and notable case and notable history and notable precedent. This Hawaii Housing Authority is going a long way to answering this question, right? If the state of Hawaii has the ability to be like, hey, renter, would you like to be a landowner? You would? And the landowner's, but I don't want to sell. And the landowner, and then the government's like, you don't have a choice. You have to sell, landowner. The renter is now the owner. That's just what's happening now. And the Supreme Court unanimously says that's fine. Again, although you're transferring property from A to B, you're doing it sort of globally. You're not doing it just with respect to one person. You're doing it in a systematic way, and also arguably doing it in a way that benefits the public at large, because the problem is that the number of people that are A and the number of people that are B are uneven, that in a very, very sort of disparate way, right? It wasn't a one-to-one thing. It was like I'm going to make up a number here, but let's say it's 1 to 10 or 1 to 100, right? We're taking from one guy and giving it to 100 guys, because the problem we were concerned about is the property being owned by too few people. So that benefits the public at large, even as we're transferring from A, not necessarily to B, but many Bs. And that maybe is the distinction that's worth the difference. Tony P, gifts 10 gift memberships in chat. Thank you very much for your continuing contribution to the channel. We do appreciate everyone who helps to support the channel financially and keeps this channel growing. We really do appreciate it because it lets me pursue options to help make this channel better and better. And hopefully with your continued support, we're going to see some pretty interesting systematic changes coming pretty soon, but we'll reveal those when they're ready to be revealed. Pressing on to the decision for the moment. Reaffirming the deferential approach to legislative judgments in the field, we concluded that Hawaii's purpose of eliminating the social and economic evils of land oligopoly quantifies a valid public use. From the hands of the few to the many is in the benefit of the public in a large way. Our opinion also rejected the contention that mere fact the statute state immediately transferred the property to private individuals upon condemnation somehow diminished the public character of the taking. It's not only the taking's purpose and not its mechanics, we explained, in determining public use, which fair enough, right? It doesn't normally matter the mechanics of the thing. It matters more about what it is on a sort of fundamental level. So the idea is we're not looking at how you did it. We're just sort of looking at what it is in the end. So yes, you seized property from a person. and gave it to many people. But that was to benefit the public, at least so far as it takes the land in Hawaii from the hands of the few and redistributes it to the friends and to the many. And incidentally, as it's worth mentioning, of course, the people who own the land were given just compensation. So they did get paid. So it wasn't, just taking it and yoinking and now it's someone else. They did get paid. They just simply didn't have a choice. So they got fair value. The government just simply seized their stuff and gave to someone else. So I suppose there's something there. At the same time we decided Hawaii Housing Authority, we decided another public use case that arose in a purely economic context. In Runkelshaws versus Monsanto, the court dealt with property provisions of the Federal Insecticide, Fungicide, and Rodenticide Act, which incidentally, I've never heard of that one before. So they got me on that one. I have to say that I have never heard of the Federal Insecticide, Fungicide, and Rodenticide Act. You got one on me. So something new for me to learn someday. In any event, under which the Environmental Protection Agency could consider data, including trade secrets, submitted by prior pesticide applicants in evaluating a subsequent application, so long as the second applicant paid just compensation for the data. So the pesticide people submit data, including trade secrets, to the EPA. That data is normally held in confidence, but what if we didn't? What if we didn't hold it in confidence? What if we gave it to someone else? It's like, that's not fair. That's my private data. We'll pay you for it. We'll pay you for it, but you have to give it up. This would be roughly equivalent at this point, I suppose, to the government forcing Coca-Cola to give over the formula for Coke. It's like, we don't want to give over the formula for Coca-Cola. How about you will? How about you just are? We'll pay you for it though, but it gets to be known by everybody. Although this deals with, insecticides and stuff, but the point still is somewhat valid. Pressing on. We acknowledge the most direct beneficiaries of the provisions were the subsequent applicants, the private parties, but nevertheless upheld the statute under the prior law. Okay. That all sounds very good indeed. We found sufficient Congress's belief that sparing applicants the cost of time-consuming research eliminated a significant barrier to entry in the pesticide market and thereby enhance competition. So, we will help people compete by forcing their competitors to hand over their trade secrets. Which, yeah, but then again, that really shouldn't surprise anyone on some level because it's interstate commerce. And you know how much the state has the ability to regulate interstate commerce. So is it really that surprising the government has the ability to say, hey, that private data you have, how about you will share it with your competitor and they can use it directly to compete against you? When it comes to the ability of the government to regulate interstate commerce, is any of that really that surprising? Probably shouldn't be, to be honest. Viewed as a whole, our jurisprudence has recognized the need of society has varied between different parts of the nation, just as they've evolved over time in response to changing circumstance. Our earliest cases in particular embodied a strong theme of federalism, emphasizing great respect we owe state legislatures and state court in discerning local public needs, which again, fair enough, right? The Supreme Court is not a super legislature, which is again, a very sort of right-wing belief, incidentally, that the Supreme Court is not a super legislature. So the various state legislatures have apparently determined for themselves this is in the public interest. So we're not going to step in and reevaluate whether it is or is not in the public interest. That is not what we're here to do. We're merely here to decide whether or not it's constitutional. And we're willing to give them a lot of deference on the way, which of course makes sense. From federalist principles, the Supreme Court should avoid stepping in and allowing states to do whatever they want to do, as long as it's not a fundamental constitutional problem. So that makes sense. For more than a century, our public use jurisprudence has widely eschewed rigid formulas and intrusive security in favor of affording legislatures broad latitude in determining what public needs justify the use of taking power. Again, that whole idea of deference, which is a very sort of traditionally conservative thing. Those who governed the city were not confronted with the need to remove blight in the Fort Trumbull area, but the determination the area was sufficiently distressed to justify the program of economic rejuvenation is entitled to our deference. So maybe not blighted in the sort of traditional sense, but it's been on hard times. So the idea that it needs a boost in sort of a revamp of what this area is something we'll consider. The city has carefully formulated an economic development plan it believes will provide appreciable benefits to the community, including, but by no means limited to, new jobs and increased tax revenue. As with other exercises in urban planning and development, the city is endeavoring to coordinate a variety of commercial, residential, and recreational uses of land with the hopes that they will form a whole greater than the sum of the parts, which is kind of what you're hoping for when you're doing a development plan. You kind of hope that everything works in concert towards a sort of systematic, unified vision that will hopefully bring things together. So that's certainly what they're hoping for. That can't be denied. To effectuate the plan, the city has invoked a state statute that specifically authorizes the use of eminent domain to promote the economic development. Given the comprehensive character of the plan, the thorough deliberation that's preceded its adoption, and limited scope of our review, it's appropriate for us, as it was in the prior case, to resolve the challenges of individual owners, not on a piecemeal basis, but rather in light of the entire plan. Which again, I think makes sense from first principles. We got to look at this thing in a very sort of global way. We can't possibly look at this as to each individual person. This is a global plan put together by the city or the state or whatever entity is doing this. In the state of Hawaii, it's like, how about the entire state of Hawaii? How about just we condemn it all? Pokemon style, gotta catch them all. How about the entire state is just condemned? Which they kind of did. And it's like, yeah, was that fair to a particular person? Probably not. But the Supreme Court is like, look, we can't kind of look at it that way. That's not really what we're doing. Neither can the legislature for that matter. Although I suppose they could. If the legislature wanted to, they could, but they don't have to. They can look at this thing in sort of a global way. So it's like, okay, this area of town needs help. As long as that makes sense, we don't necessarily have to look to each blade of grass or each tree in the forest. Looking at the forest as a whole will be fine. That makes sense. Because the plan unquestionably serves the public purpose, the takings challenge here satisfy the public use requirement of the Fifth Amendment. To avoid this result, the petitioners urge us to adopt a new bright line rule that economic development does not qualify as public use. So the Miss Kelo doesn't really like this determination for reasons that are fairly obvious. So she proposes instead, hey, Supreme Court, how about if we just had a bright line rules? Economic development is never a good enough reason. And you can kind of sense part of the problem here because a lot of the case law is against Miss Kelo. You could distinguish if you wanted to, but Miss Kelo's proposal seems to fly a little bit in the face of some of the case law that's on point. So she might have a bit of a problem. Putting aside the unpersuasive suggestion that the city's plan will only provide a purely economic benefit, neither precedent nor logic supports the petitioner's proposal. Promoting economic development is a traditional and long accepted form of government. There is, moreover, no principled way of distinguishing economic development from other purposes that we've recognized, which, to be fair, would be very difficult at best. How do you, in principle, determine economic from non-economic, particularly when it comes to land, which has a lot of economics built into it? Economics is kind of unavoidable in some way. When you're building the railroad, or you're building the military base, or you're building the highway, economics is going to come into it in quite a lot of domain. And you can try to divorce that out a little bit, but in some level, it's a little bit hard to divorce yourself completely from. The economics somewhat permeates. So trying to separate this into, okay, if the line was no economic development, what exactly does that mean is a little bit difficult to completely foresee. In our cases, upholding takings that facilitated agriculture and mining, for example, we emphasize the importance of these industries to the welfare of the state in question. In Brennan, we endorse the purpose of transforming a blighted area into a well-balanced community through redevelopment. In Midkiff, we upheld the interest in breaking up land oligopoly that create artificial deterrents to normal functions of the state residential land market. there wasn't a state residential land market because too few people own land. So how about just more people own land? There is no more land. No problem. We'll seize the land that exists and redistribute it in a more economical, in a more global way. In Monsanto, we accepted congressional purpose of eliminating a significant barrier to entry in the pesticide market. It would be incongruous to hold the city's interest in economic benefits to be derived from the development of the Fort Trumbull area had any less of a public character than any of these other comparable interests. Clearly, there's no basis for exempting economic development from a traditionally broad understanding of public purpose. Petitioners contend that using eminent domain for economic development impermissibly blurs the boundary between public and private taking. Again, our questions foreclose this objection. Quite simply, the government pursuit of public purpose will often benefit individual private parties. For example, in Midkiff, the forced transfer of properties conferred a direct and substantial benefit on those lessees who previously were unable to purchase their homes. In Monsanto, we recognize the most direct beneficiaries of data sharing provisions were in subsequent pesticide applicants, but benefiting them in this way was necessary to promoting competition in the pesticide market. The owner of a department store in Burman objected to taking from one businessman for the benefit of another businessman, referring to the fact that under the redevelopment plan, we would be leasing or selling to private developers for redevelopment. Our rejection of that contention has particular relevance to the instant case. The public end may as well or better be served through agency or private enterprise than through department or government, or so Congress might conclude. We cannot say that public ownership is the sole method of promoting public purpose of community redevelopment projects. So again, this is a lot of deference to the legislature, a lot of deference to how the legislature has viewed things, a lot of deference to the democratic process through the auspices of the elected legislature. And it's like, well, they've made the determination that this is in the public interest, and we're simply not going to reevaluate that because we're not policymakers, we're lawyers. It's further argued that without blind line rule, nothing would stop the city from transferring city A to properties person B for the sole reason that citizen B will put the property to a more productive use and pay more tax. Such a one-to-one transfer of property executed outside the confines of an individual development plan is not presented in this case. While such an unusual exercise of government power would certainly raise suspicion that private purpose was afoot, the hypothesized case posed by the petitioner can be confronted if and when it arises. It does not warrant the crafting of an artificial restriction on the concept of public use. So again, the idea here is if this is solely from person A to person B, then that is something different. And that is not this case, which it's not, right? Kelo is not being targeted. This is not a one-to-one thing. Kelo's house is simply in the wrong place at the wrong time. It's in an area which overall has seen significant problems. It is rational for the city legislature and the state legislature to look at this and be like, this area needs help. Here's how we're going to go about the help. Here's how we're going to go about solving this problem, and so forth and so on. So that all makes a lot of sense. Alternatively, petitioners maintain that for takings of this kind, we should require reasonable certainty the expected public benefits will accrue. Such a rule, however, would expend even greater departure from our precedent. When the legislative purpose is legitimate and the means are not irrational, our cases make clear that empirical debates over the wisdom of takings, no less than debates over the wisdom of other kinds of socioeconomic legislation, are not carried out in federal courts. Again, these are policy issues that are brought out before the various legislatures, not something that is brought up by the courts. Courts don't do policy, courts do law. So looking to what they is on a policy level, you are asking the wrong person. Indeed, earlier this term, we explained why similar practical concerns, among others, undermine the use of substantially adverse formulas in our regulatory taking doctrine. The disadvantage of this high-informed review are especially pronounced in this type of case. Orderly implementation of a comprehensive redevelopment plan obviously requires that the legal right of all interested parties be established before the new construction be commenced. A constitutional rule that required postponement of judicial approval of every condemnation until the likelihood of success of the plan had been asserted would be unquestionably imposing a significant impediment to the successful consummation of many such plans. So again, the idea here is, look, if we require this to be done by the judicial branch, this would require a lot of delays and problems that would then ensue. And incidentally, those problems did ensue in New London, Connecticut. The development never happened. The land was, the house was moved. They took the house and put it somewhere else. But the development never happened. The land is still vacant. To the best of my knowledge, to this day, it's still vacant. And part of the reason it might be vacant is because the delay in all this changed the economics of the situation. So it changed what Pfizer was willing to do. And so the Supreme Court is sort of pointing to the problem. Like, if you allow judicial approval of every condemnation until you met the threshold, it would mean that a lot of these condemnations would be delayed and it would impede the plan. And arguably did impede the plan in the case of New London. So maybe the Supreme Court being a bit more fortuitous than we thought there. Just as we declined to second guess the city's considered judgment about the efficacy of the development plan, we also declined to second guess the city's determination as to what land it needs to acquire in order to effectuate the process. It is not for the courts to oversee the choices of the boundary line, nor to sit on review on the sides of a particular project area. Once the question of public purpose has been decided, the amount and character of land need to be taken for the project and need for a particular tract of land to complete the integrated plan rests in the discretion of the legislative branch. Which again makes sense because in the case of Hawaii Housing Authority, the size of the project was the state of Hawaii. So, yeah. So that sort of makes sense. Once the legislature decides what the scope and size of the project is, whether that is, an area of town, or we need to build a road, or how about the size of the project is just the entire state of Hawaii? How about that? That is a legislative judgment by the political branches through the legislative process, through the powers of democracy, and we're not going to reevaluate that from a policy perspective. So yeah, we're not going to try to determine what is necessary for public policy. That's not what we do. In affirming the city's authority to take petitioners' property, we do not minimize the hardship that condemnations may entail, notwithstanding the payment of just compensation. We emphasize that nothing in our opinion precludes any state from placing further restrictions on exercise of taking. Again, of course, this is all being decided under the Constitution's Fifth Amendment. This is the floor, not the ceiling. States could, of course, as a matter of their own state laws, impose restrictions that would forbid this. And in response to this decision, many states did. Many states and their populace were very, very unhappy with this decision, and many states put in place restrictions that would have made these kinds of takings more difficult or even impossible. So that is, of course, part of the political process too. Some states took a look at this and be like, never in my state, we'll never allow this, which is a decision those states can make. Nothing wrong about it. You can always guarantee people more rights than the federal Constitution requires. And many states do, so that's fine. Indeed, many states already impose public use requirements that are stricter than the federal baseline. Some of these requirements have been established as a matter of state constitutional law, while others are expressed in state eminent domain statutes that carefully limit the grounds for taking, which, fine, fair enough. As the submissions of their party and the amici make clear, the necessity and wisdom of using eminent domain to promote economic development are certainly matters of legitimate public debate. This court's authority, however, only extends to determining whether the city's proposed condemnation are for public use within the meaning of the Fifth Amendment of the Federal Constitution. Because over a century of our case law interpreting that provision dictates an affirmative answer to the question, we may not grant relief they seek. The judgment of the Supreme Court of Connecticut is therefore affirmed. And I think in light of the precedent, which I certainly understand better now than I did as a constitutional law student so many, many moons ago, because I've read a lot more decisions and had a lot more time to think about it. I think as a matter of the precedent, this makes sense. A lot more than I used to think that it did. Now, you can certainly disagree with the precedent, which, there's ample room to disagree with that. But a lot of what the Supreme Court is saying is a natural evolution of the development of law. So in some ways, this case is less an aberration than it might otherwise appear. Perhaps it's just that Miss Kelo is particularly sympathetic because she has a cute little pink house, which, then had to be moved. And she doesn't even live in the little pink house anymore. She lives somewhere else in Connecticut. So they moved the house, and then she moved herself too. And the land remains vacant. So there's all that, but yeah. So that's all pretty interesting. Let's read a little bit from Justice Kennedy's concurring opinion. I join the opinion for the court and add these further observations. This court has declared that a taking should be upheld as consistent with the public use clause of the U.S. Constitution, as long as it was rationally related to a conceivable public purpose, citing Hawaii Housing Authority. This deferential standard review echoes the rational basis test used to review economic regulation under due process and equal protection clause. Standard test for most laws. Standard test for most laws is just rational basis. Any rational basis will be fine. The determination that rational-based standard of review is appropriate, however, does not alter the fact that transfers intended to confer benefits on particular favored private entities and only with incidental or pretextual public benefits are forbidden by the public use clause, which I think makes sense as well. It's just like if the issue is it needs to be in the public benefit. And so the issue might be one of balance. If this is only really to benefit one person, even if that one person is a corporation, then it's probably forbidden. However, if it benefits the public in a way that seems publicly salable, then that would make sense too. So there's one way to look at it. I think that kind of makes sense. A court applying rational basis review under the public use clause should strike down a taking that, by clear showing, is intended to favor a particular private party with only incidental or pretextual public benefits, just as a court applying rational basis review under the Equal Protection Clause must strike down a government classification that's clearly intended to injure a particular class of private parties with only incidental or pretextual public justifications. Pretext is not a good thing. So if you're doing something with pretext, we will look past it. As the trial court in this case was correct to observe, where the purpose of the taking is economic development, and that development is to be carried out by private parties, or private parties will be benefited, the court must decide if the stated public purpose, economic advantage to a city sorely in need of it, is only incidental to the benefits that will be confined on private parties of a development plan. A court confronted with a plausible accusation of impermissible favoritism, two private parties should treat the objection as a serious one and review the record to see as if it has merit, though with the presumption that the government's actions were reasonable and intended to serve a public purpose, which is also very typical under rational basis review. We are going to be deferring to the government. It's up to you to prove the government is wrong, not up to the government to prove it's right. That's one of the distinctions between rational basis review and higher levels of review. The burden's on you to disprove it's reasonable, and good luck. Here, the trial court concluded a careful and extensive inquiry into whether, in fact, the development plan is of primary benefit to the developer and private businesses which may eventually locate the private plan area, and in that regard, only incidental benefit to the city. The trial court considered testimony from government officers and corporate officers, documentary evidence of communication between the parties, respondents' awareness of New London's depressed economic condition, and evidence corroborating the validity of the concerns, the substantial commitment of public funds by the state to development project before most of the private beneficiaries were known, evidence that respondents viewed a variety of development plans and chose a private developer from a group of applicants rather than picking out particular transfers beforehand. Again, this idea that we were not trying to benefit particular people. The people that were benefited as a result of the plan, not picked out a priori. So again, it's a result, not a product of the thing. So that makes a difference. And the fact that other private beneficiaries of the project are still unknown because office space proposed to be built has not yet been rented. The trial court concluded based on these findings that benefiting Pfizer was not the primary motivation or effect of the development plan. Instead, the primary motivation for respondents was to take advantage of Pfizer's presence. Likewise, the trial court concluded there's nothing in the record to indicate the respondents were motivated by a desire to aid other particular private entities, and that does seem to be true. And again, this is all findings of fact by the trial court, so the Supreme Court's in no position to review it anyway. The trial court heard testimony. The trial court heard from people. Everyone had their day in court to present it. And the trial court concluded, as a matter of fact, that this was not meant to benefit particular parties. The fact that it would benefit private parties was incidental to the overall public purpose of the plan, not its intended purpose. And there's a distinction there as it relates to the law. Even the dissenting justices on the Connecticut Supreme Court agreed that respondents' development plan was intended to revitalize the local economy, not serve the interests of Pfizer or any other private party. So again, no one seemed to disagree that the benefits to Pfizer were incidental of the plan. This wasn't meant to benefit Pfizer in the first instance. Pfizer was a consequence of the overall plan, not its intent. And again, that makes a huge difference. This case then survives the meaningful rational basis review that in my view is required under the public use clause. Petitioners and their amici argue that any taking justified by promotion of economic development must be treated by the courts as per se invalid, or at least presumptively invalid. Petitioners overstate the need for such rule, however, by making incorrect assumptions that review under the relevant case law imposes no meaningful judicial limits on government's power to condemn any property it likes. A broad per se rule or a strong presumption of invalidity, furthermore, would prohibit a large number of government takings that have the purpose and expected effect of conferring substantial benefit on the public at large and so do not offend the public use clause. My agreement with the court that presumption of invalidity is not warranted for economic development takings in general, or for particular takings at issue in this case, does not foreclose the possibility that a more stringent standard of review than that announced by the prior case law might be more appropriate for a more narrowly drawn category of takings. There may be private transfers from which the risk of undetected impermissible favoritism of private parties is so acute that the presumption, rebuttable or otherwise, of invalidity is warranted by the public use clause. So they're leaving themselves open the possibility that in some case yet undefined, they may need a more stringent standard. So they're just leaving themselves open that room for the future, which again, very typical for courts. You know, it's like you don't necessarily want to foreclose all ends, just sort of forecasting the possibility that in an appropriate case, you might need to do something else. This demanding level of scrutiny, however, is not required simply because the purpose of the taking is economic development. This is not the occasion for conjecture as to what sort of cases might justify a more demanding standard, which again, fair enough, the Supreme Court doesn't do advisory opinions. But it is appropriate to underscore aspects of the instant case that convince me no departure from the other case law is appropriate here. So even though it might be appropriate sometime, it's not appropriate in this particular case. This taking occurred in the context of a comprehensive development plan meant to address a serious citywide depression, and projected economic benefits of the project cannot be characterized as de minimis. The economic benefits are not so minimal we can ignore them. The identities of most of the private beneficiaries were unknown at the time the city formulated its plans. So although Pfizer might be a benefit, that was not known to the city at the time they adopted the plan, which again shows that this is not merely a pretext. And how do you know that the city didn't know Pfizer was a beneficiary? Because again, there was a trial court decision. There was a hearing with people and witnesses and testimony and cross-examination and everything else. So the trial court found, as a matter of fact, that the city did not know who most of the private beneficiaries were going to be. So that's a factual determination. And the Supreme Court's accepting that because, of course, they are, because they're a court of law, or they're a court of appellate review, which reviews the law, not reviews the facts. So the factual determination the city was not trying to benefit these people has been determined and, of course, is accepted for its truth. There having been a hearing. That's how that works. The city complied with elaborate procedural requirements that facilitate review of the record and inquiry into the city's purpose. In sum, while there might be categories of cases in which transfers are so suspicious, or procedures employed so prone to abuse, or purported benefits so trivial or implausible, the courts should presume an impermissible private purpose. No such circumstances are present in this case. Again, just leaving yourself open the possibility that if the facts were different, the result would be different. Just so leaving yourself a little bit of breathing room, so that makes sense. For these reasons, I join the court's opinion. Okay, so that all kinds of makes sense. So that makes sense from the majority. So let's read some of the dissenting view and see how it persuades us. So this is a 5-4 decision. Very controversial at the time, as you would expect. Justice Stevens writing for the liberal majority. And now the more conservative majority is going to dissent and express its view. So let's read what the conservatives have to say about it, and we'll evaluate that as well. So Justice O'Connor writes with the Chief Justice, Justice Scalia, and Justice Thomas to write the following. Let's see, this is 20 years ago. So who's Chief Justice at this point? Is this Roberts or is this yeah, who's Chief Justice in this? Okay, anyways, pressing on, doesn't matter. Over 2 centuries ago, just as the Bill of Rights was being ratified, Justice Chase wrote, an act of the legislature, for I cannot call it a law, nice, sovereign citizen Justice Chase over here apparently, contrary to the great first principles of social compact, cannot be considered a rightful exercise of legislative authority. A few instances will suffice to explain what I mean. A law that takes property from A and gives it to B, it's against all reason and justice for people to entrust a legislature with such power, and therefore they cannot presume to have done it. Today, the court abandons this long-held basic limitation on governmental power. Under the banner of economic development, all private property is now vulnerable to being taken and transferred to another private owner, so long as it might be upgraded, that is, given to an owner who will use it in a way that the legislature deems more beneficial to the public in the process. To reason, as the court does, that the incidental public benefits resulting from subsequent ordinary use of private, yeah, it was still Rehnquist? I thought that might be true. Thank you, Tony. To reason, as the court does, the incidental public benefits resulting from subsequent ordinary use of private property render economic development takings for public use is to wash out a distinction between public and private use of property, and thereby effectively to delete the words for public use from the takings clause of the Fifth Amendment. Accordingly, I respectfully dissent. Petitioners are 9 residents or investment owners of 15 homes in Fort Trumbull neighborhood of New London, Connecticut. Petitioner William Derby, for example, lives in a house on Walbach Street that's been in her family for over 100 years. She was born in the house in 1918. Her husband, Petitioner Charles Dray, moved into the house when they got married in 1946. Their son lives next door with his family in the house that they received as a wedding gift and joins their parents in the suit. 2 petitioners keep rental property in the neighborhood. In February 1998, Pfizer Inc., the pharmaceutical manufacturer, announced it would build a global research facility near the Fort Trumbull neighborhood. That never actually happened. So, 2 months later, New London City Council gave initial approval for New London Development Corporation to prepare the development plan at issue here. The New London Development Corporation is a private, non-profit corporation whose mission is to assist the City Council in economic development planning. It is not elected by popular vote, and its directors and employees are privately appointed. Consistent with the mandate, the NLDC generated an ambitious plan for redeveloping 90 acres of Fort Trumbull in order to complement the facility that Pfizer was planning to build, create jobs, increase tax and other revenues, encourage public access to and use of the city waterfront, and eventually build momentum for revitalization of the rest of the city. Petitioners own property in two of the plan's 7 parcels, Parcel 3 and Parcel 4A. Under the plan, Parcel 3 is slated for construction of research and office space as it markets develops for such space. It will also retain the existing Italian Dramatic Club. Who knew the Italian Dramatic Club was going to make an entrance into this, which is apparently a private cultural organization? Through the homes of 3 plaintiffs in the parcel are to be demolished. Parcel 4A is slated mysteriously for park support. At oral argument, counsel for respondents conceded the vagueness of the proposed use and offered that the parcel might eventually be used for parking. To save their homes, petitioners sued New London and the NLDC, to whom New London had delegated eminent domain power. At least as to that much, I don't think that's a problem legally because, again, it's just deputizing somebody. The city has deputized somebody. It's a private person. They've deputized you. You're now the government. That's how that works. Petitioners maintain the Fifth Amendment prohibits NLDC from condemning their property for the sake of the economic development plan. Petitioners are not holdouts. They do not seek increased compensation, and none is opposed to new development in the area. Theirs is an objection in principle. They claim that the NLDC's proposed use for confiscation of property is not a public one for the purposes of the Fifth Amendment. While the government may take their homes to build a road or a railroad or to eliminate a property use that harms the public, say petitioners, it cannot take their property for private use of other owners simply because new owners may make more productive use of the property. The Fifth Amendment to the Constitution, made applicable to the states by the 14th Amendment, provides that private property shall not be taken for public use without just compensation. When interpreting the Constitution, we begin with the unremarkable presumption that every word in the document has independent meaning, that no word was unnecessarily used or needlessly added. In keeping with the presumption, we've read the Fifth Amendment language to impose 2 distinct conditions on the exercise of eminent domain. The taking must be for a public use, and just compensation must be paid to the owner. These 2 limitations serve to protect the security of property, which Alexander Hamilton described to the Philadelphia Congress as one of the greatest objects of government. Together, they ensure stable property ownership by providing safeguards against excessive, unpredictable, or unfair use of government eminent domain power, particularly against those owners who, for whatever reasons, may be unable to protect themselves in the political process against the majority will. While the takings clause presupposes that the government can take private property without the owner's consent, the just compensation requirement spreads the cost of the condemnations and thus prevents the public from loading upon an individual more than his just share of burdens of government. The public use requirement, in turn, imposes a more basic limitation, circumscribing the very scope of eminent domain power. Government may compel an individual to forfeit her property for public use, but not for the benefit of another private person. This requirement promotes fairness as well as security. Where is the line between public and private property use? That's a good question. That's a very good question, right? So if you're going to draw this distinction, that would be very helpful. Where is the line? That's a good question. The majority seems things to think we can't really find the line, or they describe it in a very nebulous way. So can the dissent do any better? Let's see. We give considerable deference to the legislature's determination about what governmental activities will advantage the public. But were the political branches the sole arbiters of the public-private distinction, the public use clause would amount to little more than hortatory fluff. Cute. An external judicial check on how the public use requirement is interpreted, however limited, is necessary if a constraint on government power is to retain any meaning. Our cases have generally identified 3 categories of taking that comply with the public use requirement, though it's in the nature of the things that the boundaries between these categories are not always firm. Two are relatively straightforward and uncontroversial. First, the sovereign may transfer private property to public ownership, such as for a road, a hospital, or a military base. I will take note, however, that a hospital isn't necessarily public ownership, but I digress. Maybe they mean a public hospital, but they don't specify. Second, the sovereign may transfer private property to private parties, often common carriers, who make the property available for the public use, such as with a railroad, a public utility, or a stadium. But public ownership and use by the public are sometimes too constricting and impractical ways to define the scope of the public use clause. Thus, we've allowed that, in certain circumstances and to meet certain exigencies, the takings serve a public purpose also satisfy the Constitution, even if the property is designated for subsequent private use. So even the minority sort of recognizes this idea in the precedent. So are they going to distinguish the precedent? Are they going to try to overrule the precedent? What are they going to do? This case returns to us for the first time in over 20 years to the hard question of when a purportedly public purpose taking meets the public use requirement. It presents an issue of first impression. Are economic development takings constitutional? I would hold that they're not. Okay, but then you have to, of course, define what an economic development taking is, which, as the majority sort of indicates, and I think with some point, it might be hard to determine what that is. So you've simply substituted one thing for another, right? You've simply replaced one difficult question with another. What is a public use? Well, it's not when it's an economic development. Okay, what is an economic development, right? You simply like redefine the question without really giving an answer. So I'm not sure how much that helps, but okay. We're guided by two precedent talking about real property by eminent domain. In Burman, we upheld takings within a blighted neighborhood of Washington, D.C. The neighborhood had so deteriorated that, for example, 64.3% of its dwellings were beyond repair. It had become burdened with overcrowding of dwellings and lack of adequate streets and alleys and lack of light and air. Congress had determined the neighborhood had become injurious to the public health, safety, morals, and welfare, and that it was necessary to eliminate all such injurious conditions by employing all means necessary and appropriate for the purpose, including eminent domain. Mr. Burman's department store was not itself blighted. Having approved of Congress's decision, to eliminate the harm to the public emanating from the blighted neighborhood, however, we did not second-guess its decision to treat the neighborhood as a whole rather than lot by lot. So at least if we're looking at it being blighted, we're willing to treat it as an entire whole. Okay. In Midkiff, we upheld a land condemnation scheme in Hawaii whereby real property was taken from lessors and transferred to lessees. In other words, from owners to renters, who are now owners. At the time, the state and federal government owned nearly 49% of the state's land, and another 47% was in the hands of only 72 private landowners. So that was the problem that Hawaii was at least trying to confront. 50% of the state of Hawaii is either state or federal government land. 47% of Hawaii is in the hand of 72 landowners. It's a little bit dominated by a very few number of players. So this is the problem that Hawaii is trying to solve. Concentration of land ownership was so dramatic on the state's most urbanized island, Oahu. 22 landowners owned 72.5% of the land. That's pretty concentrated. The Hawaii legislature had concluded this oligopoly in land ownership was skewing the state's residential fee simple market, inflating land prices and injuring the public tranquility and welfare, and thereby enacted a condemnation scheme for redistribution of title. In those decisions, we emphasize the importance of deference to legislative judgment about public purpose. Because courts are ill-equipped to evaluate the efficiency and efficacy of proposed legislative initiatives, we rejected as unworkable the idea that courts, deciding on what is and is not a governmental function and in invalidating legislation on the basis of their view on that question at the moment of decision, a practice which is proved impractical in other fields. Likewise, we recognize our inability to evaluate whether, in a given case, eminent domain is necessary means by which to pursue the legislature's ends. Yet for all the emphasis on deference, the case law hewed to a bedrock principle without which our public use jurisprudence would collapse. A purely private taking could not withstand the scrutiny of public use requirement. It would serve no legitimate purpose of government and thus would be void. To protect the principle, those decisions reserve a role for courts in playing in reviewing legislative judgment about what constitutes a public use, though the court in Burman made it clear it's an extremely narrow one. Which doesn't sound like there's very much there, to be honest, if it's extremely narrow. Sounds like the legislature can kind of do whatever it wants. So far, I don't think that the dissent is doing a particularly good job of developing what distinction it thinks there is. So I kind of hope they're going to get somewhere soon, because I'm not so sure about this. The court's holding in the case law was true to the principles underlying the public use clause. So the dissent thinks the Hawaii housing was in keeping with the public use clause. Okay. In both those cases, the extraordinary pre-condemnation use of targeted property inflicted an affirmative harm on society. In Burman, through blight resulting from extreme poverty, and in Midkiff, through oligopoly resulting from extreme wealth. And in both cases, the relevant legislative body have found that eliminating the existing property was necessary to remedy the harm. Thus, a public purpose was realized when the harmful use was eliminated. Because each taking directly achieved a public benefit, it did not matter that the property was turned over to private use. Okay. So they speak with approval of handing it over to other private people as long as there's public use in it, which incidentally, by the way, because you're handing over the land in fee simple, which is when you just own land, that's what it's called, fee simple, right? That property is not public use with respect to any individual landowner, because with respect to any individual landowner, they still have the right to trespass anybody. So the public use isn't in the nature of the land ownership individually. It can only be there in the nature of the land ownership in some sort of collective sense. Because people at large are able to own property, it's for the benefit of people at large, I guess. Here, in contrast, New London does not claim that Kelo and Wilhelmia's well-maintained homes are the source of any societal harm. Well, yes, but that is somewhat missing the point, right? The Supreme Court talks about these sort of things in the global sense. Yes, they are not claiming these properties are the problem individually. But that wasn't true in Hawaii Housing Authority, and it's not true in the DC case either, right? It's the properties at large. It wasn't the individual property. So they're shifting focus here in a way that seems a little bit illegitimate. Indeed, it could not so claim without adapting the absurd argument that any single-family home that might be raised to make way for an apartment building, or any church that might be replaced with a retail store, or any small business that might be more lucrative if it were instead part of a national franchise, is inherently harmful to society and thus within the power to condemn. I think that's a little bit misrepresenting what the majority has to say, minority. That is not the issue. Again, you're looking at this on a one-to-one basis, and the prior case law doesn't look at this one-to-one, right? The issue isn't Kelo and her house. The issue is the entire land, right? Again, was it necessarily fair to a particular, you didn't look at the individual in the DC case either. You didn't look at the store. The store didn't do nothing wrong. The store was fine. You didn't look at the individual landowner in Hawaii. They might have been fine. You looked at it in a global way. So they're shifting the ball here in a way that doesn't seem quite genuine to the majority's argument, I have to say. I'm not finding this exceptionally well persuasive. If there's a distinction to be drawn, I don't think they're doing a particularly good job at defining it, at least in my view. In moving away from our decision sanctioning condemnation of harmful property use, the court today significantly expands the meaning of public use. Does it though? Does it? It holds the sovereign may take private property currently put to ordinary private use and give it over to new ordinary private use, so long as the new use is predicted to generate some secondary benefit to the public, such as increased tax revenue, more jobs, or even aesthetic pleasure. I don't know about all that either, man. Right? This, I don't know about all that. That doesn't seem quite right. I think they're being a little bit disingenuous to the majority argument. But nearly any lawful use of private property can be said to generate some incidental benefit to the public. Thus, if predicted or even guaranteed positive side effects are enough to render property transfer from one private party to another constitutional, then the use for public use does not reasonably exclude any takings, and thus does not exert any constraint on eminent domain. I think this is disingenuous because they're looking at this on a one-to-one basis, which isn't what the majority is talking about. Right? They're not talking about a one-to-one thing. They're not talking about the store giving it to a different store. They're not talking about this on a one-to-one basis. They're talking about a city making plans that are going to cover wide swaths of area that surely will impact an individual, but it is not in the nature of impacting the individual. The nature of it is to impact things in the global sense. So I think they're being a bit disingenuous here in how they're treating the argument. There is a sense in which this troubling result follows from errant language in Burman and Midkiff. So they sort of acknowledge the precedent is not on their side, which is a good place to start. In discussing whether takings within a blighted neighborhood were for public use, Burman began by observing we deal, in other words, with what's traditionally been known as police power, which is the general power to do stuff. From there, it's declared that once the object is within the authority of Congress, the right to realize it through exercise of eminent domain is clear. Following up, we said in Midkiff, the use of public use requirements is cotemporous within the scope of sovereign police power. This language was unnecessary to the specific holding of decisions. Oh, it was dicta? They're criticizing the majority for relying on dicta in their own cases? Okay. Burman and Midkiff simply did not put such language to the constitutional test because the takings in those cases were within the police power, but also for public use for reasons I've described. The case before us now demonstrates why, when deciding if a taking purpose is constitutional, the police power and public use cannot always be equated. The court protests that it does not sanction bare transfer from A to B for B's benefit, and suggests two limitations on which can be taken after today's decision. First, it maintains a role for the courts in ferreting out takings, whose sole purpose is to bestow a benefit on private transferee, without detailing how courts are to conduct that complicated inquiry. For his part, Justice Kennedy suggests that courts may divine illicit purpose by a careful review of the record and the process by which a legislature arrived at the decision to take, without specifying what courts should look for in a case with different facts, how they'll know if they found it, and what to do if they do not. Whatever the details of Justice Kennedy's as yet undisclosed test, a little harsh there on Justice Kennedy, but okay, it is difficult to envision anyone but the stupid staffer falling for it. The trouble with economic development takings is that private benefit and incidental public benefit are, by definition, merged and mutually reinforcing. In this case, for example, any boon for Pfizer or the plan's developer is difficult to disaggregate from the potential public gains in taxes and jobs. Even if there were a practical way to isolate the motives behind a given taking, the gesture towards purpose test is theoretically flawed. If it's true that incidental public benefits from new private use are enough to ensure the public purpose in a taking, why should it matter, as far as the Fifth Amendment is concerned, what inspired the taking in the first place? How much does the government does or does not desire to benefit a favored private party has no bearing on whether economic development is taking will or will not generate a benefit for the public. And whatever the reason for a given condemnation, the effect is the same from the constitutional perspective. Private property is forcibly relinquished to private ownership. A second proposed limitation is implicit in the court's opinion. The logic of today's decision is that eminent domain may only be used to upgrade, not downgrade, property. At best, this makes the public use clause redundant with the due process clause, which already prohibits irrational government action. The government can never act arbitrarily and capriciously. It always needs to act with at least a rational basis. So that's fair enough. The court rightfully admits, however, that the judiciary cannot get bogged down in predictive judgments about whether the public will actually be better off after the property transfer. In any event, this constraint has no realistic import. For who among us can say she has already made the most productive or attractive use of their property? The specter of condemnation hangs over all property. Nothing is to prevent the state from replacing any Motel 6 with a Ritz-Carlton, any home with a shopping mall, or any farm with a factory. Again, I think that they misquote or misunderstand the majority opinion because they're, again, talking about a one-to-one thing. This is not what the Supreme Court in its majority is talking about. They're talking about this development plan. If you were talking about a Motel 6 taken over by the Ritz, you'd be doing a one-to-one thing. Or a farm for a factory, you'd be doing a one-to-one thing. Right? This is part of a massive development plan that affects many, many properties in many, many different zones with many, many different types of zoning and use. So they're focusing on the individual here, which is not what the majority is talking about. They're talking about these global grand plans to which individual persons might, by some necessity, because it's almost impossible to design any law that won't screw over somebody somewhere. It's just not possible. It's one of those things it's very difficult. The government has to always sort of act in an aggregate way. You hope that whatever law the Congress or the legislature is passing is going to benefit people in a global way. It probably will screw over somebody. You hope to keep it to a minimum. But it's very, very difficult to pass a law or a regulation that won't negatively impact somebody or who isn't opposed to it. Right? So there is sort of a focus on the individual here at the expense of the global, which when you're talking about these kinds of development plans, you're not talking about the individual. Again, if you're talking about an individual blighted property for an individual condemnation, then fair enough. But that isn't what you're talking about. You're talking about entire sections of town. You're talking about entire states and having to do that in a way. So this focus on the individual is mistaken in what the majority's analysis is talking about. The court also puts special emphasis on facts peculiar to the case. The NLDC's plan is the product of a relatively careful, deliberate process. It proposes to use eminent domain for a multi-part, integrated plan rather than for use of isolated property transfer. It promises an array of incidental benefits, even aesthetic ones, not just increased tax revenue. It comes on the heel of legislative determination that New London is a depressed municipality. Justice Kennedy, too, takes great comfort in these facts, but none has legal significance to blunt the force of today's holding. I'm not sure that's true, incidentally. I think the facts of this case very much drive the holding. and I do think somewhat blunt the holding, contrary to the dissent's opinion here. If legislative prognostications about secondary public benefits of new use can legitimize a taking, there's nothing in the court's rule or Justice Kennedy's gloss on that rule to prohibit private transfers generated with less care. Yes, there is. They kind of told you about it. It's like, in some fact, it might be a problem. Finally, in CODA, the court suggests that property owners should turn to the states, who may or may not choose to impose additional limitations on economic development. This is an abdication of our responsibility. States may play an important function in our system of dual sovereignty, but compensating for our refusal to enforce the property of the federal constitution and provision meant to curtail state action, no less, is not amongst them. It was possible after Burman and Midkiff to imagine unconstitutional transfers from A to B. Those decisions endorsed governmental intervention when private property use had veered to such an extreme that the public was suffering as a consequence. Which this seems kind of like maybe a difference in degree, but they think it's a difference in kind. I'm not sure. Today, nearly all real property is susceptible to condemnation in the court's theory. I'm not so sure that's what the majority wrote either. In its prescient words of a dissenter from an infamous decision in Poletown, now that we've authorized local legislative bodies to decide that a different commercial or industrial use of property will produce greater public benefits than present use, no homeowner, merchant, or manufacturer property, however productive or valuable to its owner, is immune from condemnation for the benefits of other private interests that will put it to higher use. This is why economic development's takings seriously jeopardize the security of all private property ownership. Any property may now be taken for the benefit of another private party. That's not at all what the majority is saying. They're strawmanning the majority argument. I have to take note, and that's not really great. But the fallout from this decision will not be random. The beneficiaries are likely to be those citizens with disproportionate influence and power in political process, including large corporations and development firms. As for the victims, the government now has license to transfer property from those with fewer resources to those with more. The founders cannot have intended this perverse incentive. That alone is a just government, wrote James Madison, which impartially secures to every man whatever is his own. I would hold that the takings in both Parcel 3 and Parcel 4A are unconstitutional, reverse the judgment of the Supreme Court of Connecticut, and remand for further proceedings. Okay, they're not having it, to be sure. That is for sure. And let's read a little bit of Justice Thomas's dissent, while my voice still has a little bit more to go. Justice Thomas dissents. Long ago, William Blackstone wrote, "The law of the land postpones even public necessity to the sacred and inviolable rights of private property." The framers embodied that principle in the Constitution, allowing the government to take property not for public necessity, but instead for private use. Defying this understanding, the court replaces public use clause with a public purpose clause. A restriction that's satisfied, the court instructs, so long as the purpose is legitimate and the means not irrational. This deferential shift in phraseology enables the court to hold, against all common sense, that a costly urban renewal project whose stated purpose is a vague promise of new jobs and increased tax revenue, but is also suspiciously agreeable to the Pfizer Corporation, is for public use. I cannot agree. If such economic development takings are for public use, any taking is, and the court has erased the public use clause from the Constitution, as Justice O'Connor powerfully argues in dissent. I do not believe this court can eliminate liberties expressly enumerated in the Constitution, and therefore join her dissenting opinion. Regrettably, however, this court errors runs deeper than that. Today's decision is simply the latest in a string of cases construing the public use clause to be a virtual nullity without the slightest nod to its original meaning. In my view, the public use clause, originally understood, is a meaningful limit on the government's eminent domain power. Our cases have strayed from the clause's original meaning, and I would reconsider them. The Fifth Amendment provides, no person shall be held to answer for capital or otherwise infamous crime unless on the presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject to the same offense to be twice put in jeopardy of life and limb, nor shall be compelled in any criminal case to be a witness against himself, nor deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. It is the last of these liberties, the takings clause, that's at issue in this case. In my view, it's imperative that the court maintain absolute fidelity to the clause's express limit on the power of government over the individual, no less than with every other liberty expressly enumerated in the Fifth Amendment or the Bill of Rights more generally. Though one component of protection provided by the takings clause is that the government can take private property only if it provides just compensation for the takings clause also prohibits government from taking property except for public use. Were it otherwise, the taking clause would either be meaningless or empty. If the public use clause served no other function, other than to state the government may take property through its eminent domain power for public or private use, then it would be surplus. Alternatively, the clause could distinguish those takings that require compensation from those that do not. That interpretation, however, would permit private property to be taken or appropriated for private use without any compensation whatsoever, which isn't really what the Constitution says at all, even a little bit. In other words, the clause would require the government to compensate for takings done for public use, leaving it free to take property for purely private use without payment of compensation. This would contradict a bedrock principle well established by the time of the founding that all takings require payment of compensation. I don't know what Justice Thomas is talking about at this point, because we're not talking about the just compensation part of the thing, so I don't know what Justice Thomas is talking about. It's off point. The public use clause, like just compensation clause, is therefore an express limit on the government's power of eminent domain. The most natural reading of the clause is that it allows the government to take property only if the government owns or the public has legal right to use the property, as opposed to taking it for any public purpose or necessity whatsoever. At the time of the founding, dictionaries primarily defined the noun use as the act of employing anything for any purpose. The term use, however, is from the Latin, which means to use, make use of, avails one sense of, employ, apply, enjoy, etc. When the government takes property and gives it to a private individual, and the public has no right to use the property, it strains language to say the public is employing the property, regardless of the incidental benefits that might accrue from the public of the private use. The term public use, then, means that either the government or its citizens as a whole must actually enjoy the taking property. Granted, another sense of the word use was broader in meaning, extending to convenience or help, or qualities that may make a thing proper for any purpose. Nevertheless, read in context, the term public use possesses the narrower meaning. Elsewhere, the Constitution twice employs the word use, both times in its narrower sense. Article 1, Section 10 provides the net produce of all duties and imports laid by any state on imports or exports shall be for the use of the Treasury of the United States, meaning it's the Treasury that will control the taxes, not to be used to any beneficial end. And Article 1, Section 8 grants power to raise and support armies, but no appropriation of money to that use shall be for a term longer of 2 years. Here again, the use means employed to raise armies and support, not anything directed to achieve a military end. The same word in the public use clause should be interpreted to have the same meaning. Tellingly, the phrase public use contrasts with the very different phrase general welfare used elsewhere in the Constitution. The framers would have used some broader term if they meant the public use clause to have a similarly sweeping scope. Other founding era documents make the contrast between the two usages more explicit. The constitutional text, in short, suggests that the takings clause authorizes the taking of property only if the public has a right to employ it, not if the public realizes any conceivable benefit from the taking. The Constitution's common law background reinforces this understanding. The common law provided an express method of eliminating use of land that adversely impacted the public welfare, nuisance law. Blackstone and Kent, for instance, both carefully distinguish the law of nuisance from the power of eminent domain. Blackstone rejected the idea that private property could be taken solely for the purposes of any public benefit. So great is regarded the law for private property, he explained, that will not authorize the least violation of it, nor even for the general good of the whole community. He continued, if a new road were to be made through the grounds of a private person, it might be perhaps extensively beneficial to the public, but the law permits no man or set of men to do this without the consent of the owner of the land. Only by giving the landowner full indemnification could the government take property, and even then, the public was now considered as an individual, treating it with individual for exchange. When the public took property, in other words, it took it as an individual buying property from another typically would, for its own use. The public use clause, in short, embodied the framers' understanding that property is natural, fundamental right, prohibiting the government from taking property from A and giving it to B. The public purpose interpretation of the public use clause also unnecessarily duplicates a similar inquiry required by the necessary and proper clause. The taking clause is a prohibition, not a grant of power. The Constitution does not expressly grant the federal government the power to take property for any public purpose whatsoever. Instead, the government may take only what is necessary and proper to the exercise of an expressly enumerated power. For a law to be within the necessary and proper clause, as I explained, it must bear an obvious, simple, and direct relation to an exercise of Congress's enumerated powers. In other words, a taking is permissible under the necessary and proper clause only if it serves a valid public purpose. In interpreting the public use clause likewise to limit the government taking a property only for sufficient public purposes replicates the inquiry. If this is all the clause means, it is once again surplus. The clause is most naturally read to concern whether property is used by the public or the government, not the purpose of taking legitimate. Well, I think that we got an idea of what Justice Thomas is saying, and I'm not really sure about any of that, to be honest. I'm not really sure about the dissent on this issue. The majority seems to be more in keeping with the precedent, but there is a lot here to chew on for sure. It's been a long time since I read this case. It's been, well, I think the last time I read the case was when it was released. I read it when it was brand new off the presses. And I think it's been the last time I read it. So I'm not so sure about the dissent. The dissent is tenuous. I tend to agree, Tony. The dissent is overall tenuous. And the majority, I think, has a better thing. And the minority's concern about this one-to-one thing is not what the majority is talking about at all. They're talking about these grand plans that benefit people, and in the facts of this case, the trial court determined that they did it without particular benefit to any private person. So if they made a different factual finding, the case would come out differently. So under the facts of this case, this answer seems to be roughly correct. So I think that's what they're talking about. So I think this was interesting. I appreciate the 77 of you who joined me to read this. It's been a long time since I read it. And it's a nice way to bring the Supreme Court back in session, isn't it? By reading an old decision that I haven't read for a while and making us think about some of these principles and how we want to view these things. They're the minorities example that you could seize the property for benefit of a hospital, I thought was particularly interesting, since hospitals are often private owned. So maybe they meant a public hospital, but I don't know about that. But I thought that was originally interesting. I think the biggest problem with the dissent is it doesn't want to, and maybe Justice Thomas is getting there, because Justice Thomas seems like he's ramping up toward it. But the principal dissent, the one written by O'Connor, accepts the premises of Miskiff and Bainoff. It accepts those premises of Hawaii housing in the DC case, and then tries to distinguish, and it doesn't really work. So I think where Justice Thomas is going, and we'll have to end it here because I'm getting a little bit tired, and we've been reading for almost 2 hours straight. But I think where he's going is he's going to question the precedent more openly. I think the dissent's biggest problem is that they accept the precedent and then try to distinguish the precedent, and it doesn't really work. If you can seize the entire neighborhood in DC as blighted, even though this one guy's thing isn't blighted, if you can do that, if you can seize the entire state of Hawaii, as an unfair oligarchical ownership and transfer private property into other private property hands, if you can do that and those grand plans, then what New Connecticut's doing doesn't seem that much different, right? The property, the area as a whole is economically depreciated, and it needs to be redeveloped. So it needs to be reconsidered on how it's set up to be more economically viable. The employment is double what it is in the state. The land as a whole is economically depreciated. And so they come up with this grand redevelopment plan that will hopefully benefit everybody in the same, or at least a comparable way to what Hawaii did, or a comparable way to what DC did. So I think the dissent's biggest problem is they accept the precedent and then try to say this is different. And the examples they use don't really work because the examples speak to one-to-one relationships. And that's not what the precedent or this case is speaking about. This case is speaking about grand things. The government taking, huge swaths of town, or the entire state in the case of Hawaii, and making redevelopment efforts on it in a way that benefits the public. In the case of Hawaii, it's even more tangential. Arguably, it's even more tangential than this, because at least New Connecticut, at least New London, had a plan of let's bring in all this development, let's bring in all these things. This will bring in jobs. People will work there. It will bring in tax revenue. It will be economically viable. Hawaii was worse because it's let's just transfer private land ownership, private homes. Let's transfer private homes from one person to another person. More to the point, one to many. But still, this is arguably more public interest than Hawaii in that sense. Because all those individual plots of land that Hawaii had when they were done, those were not within the public use. Those are private things. So that's I think the dissent doesn't quite work in view of the precedent. Yeah. Azeroth, if that's what you got out of the case, I'm not sure what case you were listening to be quite honest. This is not what they're talking about, and that's not a fair reading of the case. Also, this has nothing to do with the Second Amendment. This has to do with seizing of land for land redevelopment. So keep trying. You're talking about RoboCop. I'm not sure how RoboCop is relevant to any of this, but okay. Yeah. Okay, well, I'm not sure why you're talking about a fictional thing, but we can move on. It's not really important. I want to appreciate Tony, who gifted 10 gift memberships. Thank you very much for the 10 gift memberships. It makes a huge difference. I was looking at buying a new microphone. I was looking at the SM7DB. It's a $500 microphone. I thought that might be interesting. It's a possibility. No, it's fine, Silk Lake. We're done. We're just doing a little bit of audience participation Q&A before I wrap things up. So we're good. So I was looking at possibly getting a different microphone, make a little bit of difference. But all right, I'm going to sign off for now. I hope you've enjoyed this. I hope you enjoyed this deep dive stream. Let me know if you like things like this, and let me know what you think. And we will sign off for now. I hope you've enjoyed all this. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.